My lord, if I may, my lord, it was a suit for eviction.
Not recovery of money.
No. On that, there are arrears.
Yeah.
There was a condition that he has to vacate the property by 3 months by paying all the arrears. Then I file an execution in number.
Original, what is the amount?
I may. It was 375.
3,70,000.
For 3,25,000.
Yes.
Then
There was an attachment warrant issued so that I could go and execute the matter.
for this order is for arrest.
Yes, ma'am.
No. Therefore, the decree holder has to take steps for attachment of the mobiles.
Please.
You only said that please
but
attach
what
the
has happened,
properties,
my lord?
that mobiles.
And we have given an articles in the shop, but they did not agree for the articles. He is selling
Sir?
They did not agree for the articles. We have given a list of articles, Lord. In that value also we have given, but that they did not agree. At that point of time, Lord, she was not. Immediately after that, we have vacated and given.
Now, remaining amount, the court is not concerned. What is the order here? The court has directed for attachment of articles.
Yes, my lord.
That has,
Which you come before this court and obtained an interim
yes,
order.
Lord. In that situation, my lord, we have paid 1,61,000.
And that we are not
And-
going accepting that you have. they have
No, but
received
that
it.
24,000 they are not accepting, my lord. Thereafter, my lord, we have given an one more DD. Amount was paid on 1,80,000.
Who is the petitioner?
I'm for the petition in this case. Ma'am.
Petition is a plaintiff for the defendant.
No, he's the executive. He's a DHR.
DHR.
No, he's the DHR, my lord. I'm the
You are the judgment debtor. What is the suit for?
Suit for recovery of money, my lord.
When was it decreed?
It is in the year 2016,
16.
my lord.
What is the order impugned in the execution?
Impugned order, my lord, there is a decree of the amount which was paid. The defendant is hereby directed to quit and vacate the delivery vacant possession.
My lord, if I
suit
may, my lord,
property.
it was a suit for eviction.
Not recovery of money.
No. On that, there are arrears.
Yes.
In 2016, it was decreed. And there was a condition that he has to vacate the property by 3 months by paying all the arrears. Then I file an execution in number 2506 of 2017 in the same year. In that, we enter into a joint memo and we file a joint memo before the local Lok Adalat of senior citizens. And we mutually agree for a lesser amount, that is 3,25,000 rupees.
3,25,000. Original, what is the amount?
I may.
Uh,
It was 375.
3,70,000.
For 3,25,000.
Yes.
Then
After that, he refuses to comply with that compromise petition.
that is recorded.
That is recorded. It is there in page number 39, my lord.
Dated?
That compromise is dated 15/5/2019. Well, sorry. That is within that time he shall pay that amount.
Then you filed EP.
Then I file EP.
Uh,
That EP he compromise was not done. So I file one more EP execution. I file one more execution. That so and so was the compromise by joint memo. He has not complied with that for that. And there was an attachment warrant issued so that I could go and execute the matter. Meanwhile, this writ petition he has preferred, and this writ
and
petition is
attachment order is dated.
attachment order dated
This is
47.
dated 14/9/20.
47. On 4/6/2022, they issued
39 is the order on that.
hence AWS to JDR.
39 is the order.
39 is the order.
Please read the order.
Orders on IA number 2 that the CPC holder, the decree holder has filed an application 150 praying that issue warrant against the judgment debtor. In the affidavit accompanying application, the decree holder submits that he had filed a suit in West Numbers also against the judgment debtor for the relief of eviction and suit scheduled property, and this court decreed the suit on 6/10/2018. He filed an execution petition on number 25006 of 2018. Same was amicably compromised between the parties before special Lok Adalat to the senior citizen held on CCH 73 in the terms of joint memo filed by the parties. The judgment debtor agreed to pay arrears of rent in installments. First installment of rupees 75,000 shall be paid on or before 15/5/2019. Second installment in sum of rupees 1,25,000 shall be paid on or before 15/6/2013. Third is final settlement on 1,25,000 shall be paid on 15/7/2019. The decree holder who submits that the judgment debtor has not complied with the order of the court clear and pay the aforesaid sum of rupees 3,25,000 is agreed. The consequent upon the default on the part of the judgment debtor, this court issued an attachment warrant against the judgment. The decree holder along with the court bailiff visited the residence of the judgment debtor and could not able to find any valuable things to compensate the decree amount. Hence, they could not attach any movable properties belongs to the judgment debtor. If the application is not allowed, the great hardship
Oh.
prejudice.
So this order is for arrest.
Yes, Manoj. And
No, therefore the decree holder has to take steps for attachment of the mobiles.
please,
You only said that
No,
please
but
attach the
what has happened,
properties,
Malad?
that mobiles.
no, what has happened, we have given an articles in the shop, but they did not agree for the articles. He is selling
Huh?
they did not agree for the articles. We have given a list of articles, Lord. In that value also is given, but that they did not agree.
Hmm.
We are
So what is that now they are going to attach?
no, apart from that, my lord, he doesn't have that.
If you don't have anything, leave it then.
No, already keys are already handed over, my lords. In the earlier, much earlier, keys handed over to him.
Please come to page 44.
Let's, at that point of time, my lords, he was not, immediately after that, he
What is the
vacated and
situation
given.
now?
Well,
Mr. Counsel,
My lord,
what is the situation now?
situation now is, there's been, this,
Well,
because of this
I'll
petition, we
take-
have not executed, my lord. They are
Remaining
pending
amount
of
is
3,75,000 rupees.
No.
It is not about remaining amount, the court is not concerned. What is the order here? The court has directed for attachment of articles.
Yes, my lord.
That has,
Which
my
you
lords,
come before this court and obtained an interim
yes, my
order.
lord. In that situation, my lord, we have paid 1,61,000.
That we are not
And-
going into, that is before the executing court, whatever is required to be done
And-
and whatever is the calculation. they will
Interim
take
order
care
is
of it.
concerned, my lord, we have complied it, my lord. Interim order as the only thing is, my lord, we have given a cash of rupees 24, that they did not accept it. They're saying that we are not receiving any cash. Before that, before the executing court, my lord, we have submit that we have paid the cash at the time of executing the, at the point of execution, my lord. We have given a cash. That is along with the memo I have produced it, my lord.
Are they accepting that you have, they have
No, but
received
that
it?
24,000, they are not accepting, my lord. Thereafter, my lord, we have given an one more DD, that is 24,000 we have deposited. Entire amount has been deposited for the this honorable court interim order.
Where is the order?
Yes. Order was.
Subject to payment of a
Please.
sum of rupees?
On
Respondent,
29th
that is
July 2022, my lord.
No, the entire amount is not paid.
No, I'm not saying that I didn't pay any entire amount, my lord. Only the part of amount has been paid.
1,85,000.
Yes, my lord, that has been paid. That has been paid, my lord. I have
Where is
produced,
the memo?
let's, in that memo,
Look at it.
it is there in the,
That was the condition for the stay.
yes,
No, was it deposits, was it paid
but
to you?
18/11/22 to
It's not been
2022,
received
my
by
lord.
us.
How did you pay?
Yes, ma'am, entire amount has been deposited. Not entire amount.
What-
I'm asking you, how did you pay? What is the
Plus,
mode
one
of
is
payment?
one amount is 1,61,000 is the DD on 23/8/2022. Remaining balance was collected by the respondent on 25/7/2022 at 3:35 PM by way of a cash in front of Nanjunda Swami HT, Court Amina.
Did you
Police.
pay any amount by way of cash?
No,
If you don't
that-
agree for that, if you say that he has not received, how do you prove it?
In front of the bailey, my lord, and one Mr. Constable, police constable, and his brother also was there.
Then now, why you now don't have any instructions? What is the payment? How much is,
My lord, 1,61,000 has been received.
and what about that money
No.
he is referring to?
No, my lord, it's not. been.
Another amount, my lord, 24,000
No, if
also
it
paid.
is- If
But
if
the-
it
the-
all
the-
it has been deposited there, my lord, the only question which has to be discussed now is to be his eviction, my lord.
That's 18/11/2022.
And there is a compromise wherein he agrees that within 3 months, he'll evict the premises.
That has been already done, my lord.
My lord,
Thing
it's
is,
a
the
settled
amount has
principle
been
of law.
Amount,
the compromise
amount
is
is
entered.
due, my lord, because he is unable to pay because of corona.
But what to do, what the court can do for that? It can't,
No, let's-
forever a stay will be granted to you.
Thing
No.
is, my lord, the concern, the only concern about 25,000, my lord, he's a very poor, my lord, he is not doing any business. He's not doing, he's working
The
somewhere. else.
judgment and decree,
No, that is true. my
which is staring at you. Unless and until he
No.
compromises or he agrees for whatever it is, court cannot compel him to do.
lord. For that, my lord, yes,
Whatever has to follow, has to follow.
1,85,000 rupees has been complained, my lord.
No, 3,75,000.
That is,
He agreed for 3.25. No, 3.25, again you can't bargain.
no, for that, my lord, 50,000 has been, if he fails that, he has to pay extra 50,000.
No.
That is,
This
That is-
court is not concerned with what is happening. No, this court is concerned only with the impugned order. There is nothing wrong with the impugned order. We'll dismiss the impugned order, whatever has to follow. We'll record what is the order of the court and what is your contentions. And that he is not accepting that payment of so-and-so.
cash is concerned, my lord.
That
Only
if before the executing court, if you have
that
to
may be
prove it,
because that liberty has to be reserved for me because I'm unable to prove it apart.
Why
from
did
that.
you give like that?
No, at that point of time, my lord, because he is running a business at that point of time, my lord. If they close the shop, he cannot do the business. That is the reason he has paid 24,000 at spot. He is received from his brother 11,000 and he has withdraw from the ATM. That also I produced along with I kindly will.
It's always for you to prove it, that this court can't.
On
there's no
18,
question.
18/11/2022. The Lord
That
should
your
kindly-
memo and the order both will record and let it is,
Please, please.
will satisfy this order first. This interim order and will
Please,
dismiss your writ petition.
please.